The Supreme Court has just issued a 9-0 ruling that has received remarkably little attention given its constitutional significance. And what I intend to analyze here is precisely why that silence is a problem for anyone who owns a firearm in this country. 9 justices, 0 disagreement. That outcome almost never occurs on a court as ideologically divided as this one, and when it does, it signals something important. Not a close legal question resolved by a narrow majority, but a constitutional principle clear enough that every justice across the full ideological spectrum of the court found the same answer. This ruling strikes simultaneously at the Second Amendment and the Fourth Amendment, which means the right to keep firearms and the right to be free from illegal searches both received significant reinforcement in a single decision. The case is called Caniglia versus Strom, and the Supreme Court of the United States decided it on May 17, 2021. For years before this ruling, police departments across the country were using something called the community caretaking exception to enter people's homes and remove their firearms without a warrant. That phrase sounds administratively neutral, even benign, but what I observe when I examine how it was actually being applied is something considerably more troubling. A legal doctrine developed for a narrow and specific purpose that had been quietly expanded into a broad instrument for stripping lawful gun owners of their legally owned property with no judicial oversight whatsoever. The highest court in the land has now shut that practice down unanimously. Not a single justice dissented. To understand what the court decided and why it matters, I need to begin where the case itself began, with a real man in a real home on a real night in Cranston, Rhode Island. Edward Caniglia and his wife had a serious argument inside their home. Emotions were running high, and in the middle of that dispute, Edward did something dramatic. He picked up one of his handguns, placed it on the kitchen table, and said to his wife words to the effect of, "Shoot me now and get it over with." Edward did not shoot anyone. Nobody was physically harmed, but his wife was frightened enough that she left the house that night, stayed elsewhere, and called police the following morning to report what had happened. When officers arrived, they assessed the situation and concluded they needed to check on Edward's welfare. They spoke with him, brought him outside, and made him what I can only describe as a conditional offer. They told Edward that if he agreed to go to the hospital for a voluntary psychiatric evaluation, he could return home afterward and everything would be fine. Edward agreed. He believed he was cooperating in good faith, that his cooperation would be respected, and that his home and his property would be exactly as he left them when he returned from the hospital. What happened while he was gone is the factual core of this case, and the reason it eventually reached the Supreme Court. While Edward was sitting in that hospital doing precisely what police had asked him to do, officers returned to his home. They entered without a warrant, they located his firearms, they took them. When Edward returned after an evaluation that found nothing clinically wrong with him, he asked for his guns back. Police told him they could not return them. He had cooperated in good faith and been deceived in return. His legally owned property was gone, and at no point had anyone asked a judge for permission to take it. Edward Caniglia did what any citizen in his position had every right to do. He fought back through the courts. He sued the officers and the city, arguing that entering his home and seizing his firearms without a warrant was a clear violation of his Fourth Amendment rights. The Fourth Amendment is the constitutional provision that shields individuals from unreasonable searches and seizures. In direct and practical terms, it means the government cannot enter your home and take your belongings without first obtaining a warrant from a judge. Edward's case on this point was straightforward. No warrant was obtained, no judge approved anything. Officers made a unilateral judgment and acted on it. The police and the city defended themselves in court using the community caretaking exception. That doctrine originated in a 1973 Supreme Court case called Katie versus Dombrowski, in which the court held that police could sometimes search a vehicle without a warrant when acting as community caretakers, meaning when they were responding to a public safety situation rather than investigating a crime. The original logic applied to vehicles on public roads, a car broken down on a highway, an abandoned vehicle blocking traffic. These were the kinds of situations the 1973 court had in mind. Officers in those circumstances should not need to obtain a warrant every time they open a car door for legitimate safety reasons. That reasoning was narrow, contextually grounded, and tied specifically to the distinctive legal status of automobiles under the Fourth Amendment. What I observe in the decades between 1973 and 2021 is the systematic expansion of that narrow vehicle doctrine into something its original architects never contemplated. Police departments across the country took a rule developed for cars on public roads and stretched it to cover private homes. They argued that if officers believed someone inside a residence was in danger or posed a danger to others, they could enter without a warrant and seize property, all under the community caretaking banner. Lower courts in multiple states permitted this argument to stand. Gun owners had their firearms removed during mental health calls, during domestic disturbance calls, during neighbor complaint calls. No judge was involved, no warrant was signed. An officer made a personal assessment and walked out of a home with legally owned property. That is the practice the Supreme Court was asked to evaluate in Caniglia versus Strom. The court's answer was unambiguous. Justice Clarence Thomas wrote the majority opinion, and all 9 justices signed on to the core holding. The community caretaking exception does not apply to the home. The reasoning rested on a principle with deep roots in both English common law and American constitutional tradition, that the home occupies a categorically distinct position in Fourth Amendment jurisprudence. It is the most constitutionally protected space the law recognizes. It has been treated that way for centuries, long before the American Republic existed. A car on a public road and a private residence are not legally equivalent spaces, and a doctrine developed for one cannot simply be imported and applied to the other because doing so would be convenient for law enforcement. What this means in practical terms is a direct change in the legal landscape that existed before May 17th, 2021. If police arrive at a home because a neighbor made a call or a family member expressed concern, they cannot enter and take firearms simply because they believe the occupant might be upset or might pose some generalized risk. Good intentions are not a constitutional justification. A neighbor's phone call is not a warrant. A family member's concern is not a court order. The right to refuse entry exists, and it exists with the full weight of a unanimous Supreme Court ruling behind it. If officers believe the situation genuinely requires them to enter, the legal mechanism for that is a warrant obtained from a judge, not a unilateral decision made at the front door. The practical implication of this ruling is best understood through specific scenarios because the abstract constitutional principle needs to be translated into the actual situations that gun owners encounter. Consider a situation in which a neighbor calls police to report that a resident seemed upset recently and they are worried. Officers arrive at the front door, present themselves in a friendly manner, and ask to come inside for a few minutes just to make sure everything is fine. Before Caniglia, many gun owners allowed them in, not understanding that a legally owned firearm visible inside the home could be taken under community caretaking once officers had crossed the threshold. After Caniglia, the occupant can tell officers calmly and clearly that they appreciate the concern, that they are fine, and that they do not consent to any entry into their home. If officers believe entry is necessary, they know how to obtain a warrant. That is the legally appropriate response. And it is now constitutionally grounded in a way it was not before. Consider a second scenario, a domestic dispute inside a home, voices raised, someone calls emergency services. Officers arrive while the situation is still tense. One officer asks the resident to step outside to talk while his partner enters the home to, in the officer's words, make sure everyone is safe. Inside, the partner observes legally owned firearms on a shelf and takes them for safekeeping. Before Caniglia, departments routinely justified exactly this kind of action under community caretaking. After Caniglia, that seizure is constitutionally suspect in the absence of a genuine and immediate emergency that would justify bypassing the warrant requirement. The legal options available to a gun owner in that situation today are meaningfully different from what existed 5 years ago. Consider a third scenario, and this is where I observe the ruling's most direct application. A person goes through a difficult period, a divorce, a job loss. A family member calls a non-emergency line and tells police they are concerned about the person's mental state and their access to firearms. Officers arrive and explain that a loved one filed a concern and they would like to take the firearms temporarily just until things settle down. They frame this as the safe and sensible course of action, without a court order, without a warrant, and without a genuine life-threatening emergency occurring in front of them at that moment. Police do not have the constitutional authority to enter the home and remove the property. The resident can decline. And if officers take the firearms anyway, Caniglia versus Strom is now the foundation of the resulting legal challenge. There are myths circulating about what this ruling means, and I want to address them directly because acting on a misunderstanding of a Supreme Court decision can produce consequences that are both serious and avoidable. The first myth is that Caniglia means police can never take firearms from a home without a warrant under any circumstances. This is incorrect. The Fourth Amendment has always recognized exceptions to the warrant requirement in genuine emergencies, what the law calls exigent circumstances. If someone is actively threatening another person with a firearm, if there is a hostage situation, if a life is in immediate danger inside the home, right now, police can and will act without waiting for a warrant. Caniglia closed the community caretaking loophole. It did not eliminate every tool available to law enforcement in a genuine crisis. The distinction between a real emergency and a manufactured excuse for skipping the warrant process is the distinction that matters. The second myth is that this ruling automatically returns firearms to everyone who had them taken under community caretaking before 2021. That is not how Supreme Court precedent works. The ruling establishes a legal principle that guides future cases and reopens the door to challenging past ones. But that challenge does not happen automatically. It requires action, filed in the right court, in the right way, within applicable time limits. Anyone who had firearms seized during a welfare or wellness check without a warrant before this ruling should treat Caniglia as the starting point for a conversation with an attorney who specializes in Second Amendment and civil rights law. The ruling provides powerful legal grounding. It does not self-execute. The third myth concerns the scope of Fourth Amendment protection more broadly. The home receives the strongest protection the law provides. A vehicle receives considerably less. A public space receives less still. Caniglia reinforced the principle that the home is constitutionally distinct, but that distinction does not extend automatically to other contexts. The constitutional rules that apply when police knock on a front door are not the same rules that apply when they ask to search a car at a traffic stop. These are legally separate situations governed by separate doctrine, and conflating them produces a misunderstanding of rights that can have real consequences. What I observe when I situate Caniglia within the broader trajectory of Second Amendment jurisprudence is a pattern that is analytically significant. The court's 2008 decision in District of Columbia versus Heller established that the Second Amendment protects an individual right to keep firearms in the home. The court's 2010 decision in McDonald versus City of Chicago extended that protection against state and local government action. The court's 2022 decision in New York State Rifle and Pistol Association versus Bruin changed the entire legal test for evaluating firearms restrictions, requiring that any such restriction be rooted in the historical tradition of American firearm regulation at the time of the founding. A restriction without that historical grounding is, under the Bruin framework, likely unconstitutional. When Bruin and Caniglia are read together, what emerges is a constitutional framework of considerable force. Bruin protects the right to own and carry firearms from substantive government overreach. Caniglia protects the home from being entered and the firearms inside it from being seized without the judicial process the Fourth Amendment requires. Together, they address the two principal vectors through which firearms rights have been practically eroded, through substantive restrictions on ownership and carrying, and through procedural workarounds that allowed removal without meaningful judicial oversight. Each ruling reinforces the other, and each is grounded in the same underlying constitutional commitment to judicial process as the gate through which government power must pass before it can reach the individual. Rights do not typically disappear in a single dramatic moment. They disappear gradually through accumulated small exceptions, each one sounding reasonable in isolation, each one framed in the language of safety and good intentions. Community caretaking sounded reasonable. Temporary safekeeping sounds reasonable. Good intentions can be invoked to justify almost anything, and the history of constitutional erosion is substantially a history of well-intentioned exceptions that expanded beyond their original boundaries until the original rule was no longer recognizable. What I observe in Caniglia versus Strom is the Supreme Court drawing a hard line at exactly the point where that expansion had become most consequential for gun owners, the threshold of the home itself. 9 justices agreed that the line had been crossed. 9 justices agreed on where it belonged. That consensus, in a court as divided as this one on as many questions as it faces, represents something worth understanding in full, because the protection it provides is only available to those who know it exists. And that is precisely the point at which I want to close this analysis, because the full significance of Caniglia versus Strom is not contained in the specific facts of Edward Caniglia's case, as instructive as those facts are. It is contained in what the ruling represents as a constitutional statement about the relationship between the individual, the home, and governmental power. The home has always occupied a singular position in the legal architecture of individual liberty, not as a matter of sentiment, but as a matter of doctrine developed across centuries of Anglo-American legal tradition and reinforced repeatedly by courts at every level. What the community caretaking exception had been doing in the years before this ruling was quietly dismantling that position one welfare check at a time. Each individual instance could be framed as reasonable. The cumulative effect was the systematic normalization of warrantless entry and warrantless seizure in the one space the Constitution most clearly protects. The unanimity of the court's response is the detail I return to when I consider the long-term significance of this decision. This was not a 5-4 ruling that a future court could easily revisit. This was 9 justices across every ideological division that currently defines that institution, agreeing that the line had been drawn in the wrong place and needed to be moved back to where the Constitution had always located it. That kind of agreement is rare, and its rarity is itself analytically meaningful. It signals not a contested legal question resolved by a temporary majority, but a foundational principle that the court, as an institution, was prepared to defend without qualification. What that means for every gun owner in this country is straightforward. The constitutional fortress the Fourth Amendment built around the home is standing. The court has confirmed it unanimously, and the legal framework surrounding it continues to strengthen. Knowing that is not merely academic. It is the foundation on which every practical decision at the front door, in the attorney's office, in the courtroom must be built.